The recent Schrems II decision has focused a number of companies in the US, as well as, frankly, European regulators on what exactly the scope of 702 of FISA is. It's an issue that obviously was discussed in the case, as well as 215, which was a different tool that had been used in the past. And so one of the key things really for companies as they look at SECs and future transfers is to really understand the scope of 702. So who is subject to 702? The short answer is electronic communication service providers is defined under FISA, and that's a 5-prong definition that you see here. And so you see obviously a telecommunications carrier is defined by federal law. Two of the key definitions here are an ECS and an RCS, as those terms are defined by different portions of ECPA that we'll speak about. Any other communication service provider who has access to wire electronic communications as they're transmitted or stored, and then officers, employees, agents, or any of these entities. And so it's important to sort of ground ourselves in what this covers and what it doesn't, as we'll talk about. Given modern infrastructure, some of these things matter directly and some of them matter indirectly, but what we'll focus on today is really the ECS and RCS portion. One thing to be aware of when we're interpreting ECPA, which we will be talking about at least today, is that courts have noted that ECPA is famous, if not infamous, for its lack of clarity. And so the terms that we're using are not always the easiest to apply in a straightforward way, and that does add to the complexity of both analyses under ECPA as well as FISA. I think one thing that may be getting lost in the shuffle is who is sort of considered to be subject to FISA and whether that's a direct or indirect issue. And by that, I mean, most companies, if they transmit or store data, they frequently have as a company that's an ECS or an RCS or multiple ones in their ecosystem. And so as you begin to look at the issues under 702, while it may be tempting to look just directly at your company, you also have to consider where else data is stored and data is going and what applications or other systems, information storage systems you're using. So as we'll talk about towards the end, I think in many ways this may become more of an issue of looking at the type of data involved and how likely it is to be subject to a FISA request versus the exact neat definition of whether your company directly is an ECS or an RCS, at least if you have some or many ECSs and RCSs in your information ecosystem. When we look at what an ECS is, it really ties out to two key definitions under ECPA that are used for a variety of purposes, and that's a wire communication and an electronic communication. And you can see those definitions here. And an ECS is really any service that provides those services, specifically the ability to send or receive wire or electronic communications. And this is one of the key distinctions in ECPA, which is ECSs really are entities that provide the connectivity. And if storage is provided for data, it's a bit more incidental to the service rather than as we'll talk about with an RCS. And an RCS really is an entity that provides to the public computer storage or processing activities by means of an ECS. And so obviously an RCS is a different type of service, and this really focuses more on storage of information and processing of information rather than transmission of information. And so you can see, based upon these definitions, these are different services, but you can also understand how many of these different entities you may have in your ecosystem, whether it's cloud or whether it's other types of service that simply process data that has been communicated, if you will, through an ECS. And looking at the definition of an electronic communication, which we saw one slide earlier, it's a very broad definition. And so as we continue to sort through Schrems II, again, as we have to note that it isn't probably just sufficient to say this type of entity is not either of those things, which obviously is the first step, but the steps that need to be taken really are, is the entity using an ECS or an RCS to gather or collect data and process data, and how likely is it that any of the ECSs and RCSs in that company's information ecosystem are getting FISA requests or could get FISA requests sufficient to raise concerns under SECs. Again, I think while it's not exclusively the analysis, I think a huge part of that analysis is looking at the data set itself to see if it's something that, independent of whether there is an ECS or RCS in the system, that the US government would be seeking. And so I'm certainly in no way saying throw the definition of who's subject to 702 out, but I think it has to be looked in that broader context of not just the company, but rather who that company's service providers may be.